Hey, so what happens when someone passes away? How do you handle it? Do you need an attorney? We're going to find out. Stick around. Hey guys, welcome to another episode of Suits and Boots Legal Talk. I'm here this morning with Kolin Funk, one of the attorneys at Bimbo, Davidson and Martin. My name's Luke Martin, one of the partners there. So today we're going to be talking about what to do when a family member or loved one passes away. And that's, gosh, it's got to be one of the hardest things that people go through. I mean, we've talked on this podcast before about when folks come through our door, they're dealing with really hard things. Mm-hmm. And this is definitely one of those things, whether it's a divorce or something else. But in this case, family member has passed away, and do they need an attorney? What do they do? And that's what we're going to talk about today.
Yeah, absolutely. It's a big topic. So,
well, and I know, Kolin, that's sort of what you've stepped into in our law firm. You do a lot of estate planning, which we're going to talk about in another episode. So stick around and look for that. But today we're going to talk about estate administration. And that's just when someone passes away, right? Tell us broadly, what is estate administration?
Yeah, so estate administration is really kind of the process of getting your things that you own during your life switched over to your heirs or your beneficiaries after you die. Some people think it's just as easy as, I've died, my kids will get my stuff, it'll kind of sort itself out. That's typically not the case. Usually with things that you own alone, the clerk of court is going to have to monitor the process of that stuff getting switched over to your kids' names or your spouse's name or whoever it's going to.
One of the things that we've seen, especially even since I've started practicing almost 10 years ago, this process has not gotten shorter. It's actually gotten quite a bit longer, hasn't it?
Yeah, it has. It's just because of, I guess, the volume of people that are doing it at any given time, and the amount of people over at the clerk's office who are assigned to be working on this stuff. Sometimes it can take over a year to get this kind of thing done. We try to get it done quicker, but there's some things that are kind of naturally time gated that we'll get into, like the notice to creditors. But yeah, the process can take a little while.
Yeah.
And it is not necessarily the most intuitive process, but it's what we found to work, and it's where we're at.
Yeah, one of the things I remember from law school is our professors talking about probate avoidance and things that you can do to avoid probate. And when we say the word probate, we're just talking about estate administration.
That's right.
It's those words are synonymous. But I remember my professors always talking about how expensive probate was, and I thought, gosh, it can't be that bad. But it's the time and it's a lot, isn't it?
Yes, it can add up. Not through anybody's fault or because of anybody trying to get something out of you, but it's really just the process of getting it done. If you have an account open that your mom died and she had a bank account that stayed open for a couple months after she died, and there's been little charges going in and out, you need to have statements that show where all these charges are going. As far as paying bills and stuff like that, you need to keep track of where bills are going to. So it's a lot of accounting really that goes into it, just adding things and subtracting things till you have a final number, and that's what the clerk is going to approve to kind of distribute things out.
So I think one of the more important things we can say from the outset is, if you are not to the point where your loved one has died and you don't need estate administration yet, if you can come see us before that happens so that we can get things in order, we can avoid a lot of this pain and a lot of this struggle and expense that you have after someone passes away.
Absolutely.
Yeah.
We for estate planning, which we'll talk about in another episode, that's really our biggest goal in estate planning, is to try and get you kind of a plan together so that this probate process is either not necessary or really streamlined, and that's our goal in doing that.
Yeah. But if that's not the case, so if you've searched for this video and you found us, someone in your family maybe has died and it's too late for the planning process, and that's okay, because we can help with that, and there's things that we can do. It's going to be a long process. We want you to know that up front. It's probably not going to be something quick and easy, although sometimes it is.
It can be.
Sometimes it is. So we're going to get into some of the weeds here a little bit, maybe, and talk about that. One of the things that I've always told folks when they call about, I just got a call the other day. A lady said, "Hey, my mom's in hospice. It's not going to be long. What do I need to do?" And so my response to her was, well, just stay with your mom and be with your mom. And and walk through this process and grieve and take your time. Because I think folks we've had folks show up at the office, a day after the loved one passes or something like that. And that's okay, but you don't have to be in a rush. You take your time and grieve, because this is a really difficult process. It's a really difficult season that you're going through. And I think I'm correct in saying that you can't open the estate immediately, right? There's a certain time you have to wait.
I found that the thing that time gates people the most is getting these death certificates, and typically the funeral homes will handle getting those for you. And then there is some mechanisms where you have to wait for 30 days or so to get an estate opened up, depending on what you're doing. And again, we'll kind of get into that in a little bit. But I've found typically that it's really waiting on getting the death certificates, and that's what I'll tell people too. The same thing is that they'll come in shortly after a loved one has passed away, and I'll just tell them, like, look, this, the chips have kind of fallen how they're going to fall at this point. So as far as getting this done, please take your time to grieve, and we can kind of get to the nitty gritty of it when you're ready to. So that's one thing that I think people need to know, is that you don't need to rush in to get something done. Take your time, within reason, to come to peace with it, and then come see us.
And that's one of the things I love about our law firm, is we're here to help with legal things and get you into the courthouse and get the estate administered and do the probate process and all those things and everything that goes along with that. But I think one of the things that I really like about the culture of our firm is that we're here to care for you. It's not just about getting your legal stuff done. We want to help.
Yeah.
We want to make sure that you're healthy and that your grief process is working right. I mean, we're not counselors. We don't do mental health and stuff like that. But at the same time, we do want you to know that we care about what you're going through. And it's not just about getting to the courthouse and getting that stuff done. We want to make sure and take care of you as best we can, and make sure that we advise you in a way that takes into account the grief and the hurt and the pain that you're going through and those kind of things. Because this is painful. That's just all there is to it.
Yeah.
So when it comes to an estate, if our loved one has passed, do we immediately, obviously, so we can wait, but I mean, is it always going to be an estate?
No, and that's one of the things that we kind of talked about before we were sitting down to do this, is that it's kind of a hard topic to broach, in terms of it relies solely on the typical lawyer answer of "it depends," in that we were talking about it, and there's not one way or one size fits all that kind of go with probate. It really just depends on what your situation is. But no, to answer your question, if someone dies, it's not a foregone conclusion that they absolutely need to probate the will or go through the estate administration process. No.
Yeah. So we talk about that a lot, and we have a lot of folks who come in, and we can advise them what are some different options if we're not going to do an estate and a full estate administration. What other things might happen?
Yeah. So typically the kind of alternatives to full probate that we deal with the most would be a small estate. And a small estate kind of takes some of the pieces of a full estate administration, but is only really used when there's less than $20,000 in the estate. And it really kind of just avoids the notice to creditors period that we're going to talk about in full estate administration. Another one that we typically use would be the yearly allowance, which actually just changed on March 1st of 2024. So there's kind of a point in time where there's how it went before and how it goes now. Moving forward from March 1st, 2024, the spousal allowance or the yearly allowance allows the surviving spouse to basically get the first $60,000 of personal property. And that's to kind of carve out a nest egg for a surviving spouse who's just lost their loved one. And it is to really kind of carry them through that first year, the first time period, while they're getting the rest of the estate administered. And sometimes that spouse's allowance is all you need to do. They really just had the $60,000 in personal property, and that'll cover everything. If not, and they have more, you'll get your first, your spouse's first $60,000 of the stuff that they owned alone, and then you administer the rest of the estate or do a small estate. So a lot of this stuff can be used in conjunction with each other. So small estate, spousal allowance, and then another mechanism that we use sometimes is the summary administration, and that's also for surviving spouses. The summary administration kind of is a way of you just saying, whatever my spouse owned and whatever debts they had, I'm going to entitle myself to. So it kind of is, that one's pretty quick. You really just fill out a piece of paper, filing fee and everything like that, submit it to the clerks, and then they'll sign a document that says you're entitled to everything, but you're also entitled to all the claims against their estate as well. So
yeah. So and then at times maybe you don't even open an estate, right?
That is that's one of the things that kind of we like to plan for, is that getting everything kind of switched out of their names. This is something we'll get into, probate versus non-probate assets, but essentially get everything to be non-probate assets. That means that your bank accounts are titled jointly with rights to survivorship or pay on death with a loved one. Your real estate is kind of titled the same way. You do a deed to your kids or a deed to your spouse if you don't already own it together, saying that, when I pass away, you're the joint owner and you just take my share with you. So that is one of the things that we try and encourage people to do is plan to make it where you don't have to probate anything just because it's already kind of done by operation of law.
So the important thing is really, if you're in this situation where you're like, okay, do I need to open an estate? Do I not? Do I need this small estate? Can I do the spousal allowance? They need to come talk to you, right? I mean, just get in touch with Colin and go see him and say, hey, what do we need to do?
That's what we, when you come to see me after a loved one's died, there's no obligation to retain us to do it. And I'll tell you the same thing if you come to see me that I've told, almost everybody else, is that this is something that you can absolutely do yourself. We're here to help guide you in what's the most efficient way to get your loved one's estate done, and whether that be for us to handle it for you or us to kind of point you in the right direction and let you take over on it. It's something that you can do yourself. But again, we know we've seen it before, and we're happy to help in any way that we can.
Yeah. So we can look at the assets and the things that they had, the estate planning documents they had, whether they had a will or didn't have a will, the family, those kind of things, and make determinations as far as, okay, here's the type of estate we should do.
Yeah.
And what I've found is if you go to the clerk's office, oftentimes their default is going to be a full administration, right?
Yeah, and I think that's just to cover their bases. But yeah, they'll kind of give you a form and check the things that they're seeing that you need. And their famous line is, "We can't give legal advice." And I think that's kind of the shortcoming of going there, is that there have been people who have gone there and been able to get it done, but that's something that we can kind of give that they're not allowed to, is that we can give you legal advice and kind of point you in the most efficient way to do it, as opposed to the clerks who they'll always let you fully probate something, and that's just really something that I think is easier to track for them. But it may not be the best way to go for your particular situation.
Yeah, we've had I've had multiple clients come in and they've already been to the clerk's office and started the estate administration process, and you look at it and you think, oh no, why did you do that? But it's because that's and the clerks are good folks, and that's what they know.
Yeah,
and they don't, like you said, they don't give legal advice, and
that's
so
right.
For them, it's just, this is what we do.
Yeah,
and so for us though, we can look at it and make a strategic plan. Like here's the best way to move forward with this. And maybe it's full administration, but maybe it's not.
Yeah.
And that's something that's probably, once you start that full administration, there's no going back.
Yeah.
You need to decide on the front side what we're going to do. And if we don't want full administration, then we can avoid that.
And yeah, on that same turn is that it's kind of the opposite. If you start a small estate, there's nothing that's going to stop you from going to a full estate. So, it may be better to start with one of the alternatives to full estate administration, then open it if needed. But Luke is absolutely right. If you start with a full probate, then you're locked in.
Yeah. So here's the thing that happens, because I'm the real estate guy at the law firm. They call me, and this is the administrator or the executor of the estate. I guess we need to talk about what that is.
Yeah.
But the administrator or the executor of the estate calls me and says, hey, I'm selling Mom's house, and we've got a buyer. We've already got a contract. Here it is. And I look at the contract, and the executor signed it. and I look at the will, and the will says I leave everything to my children, and there's 5 children. Is there a problem there?
There is a problem there. To kind of bring it full circle, the difference between the executor and the administrator is that an executor is the personal representative who's named in a will. The administrator is kind of the personal representative that's appointed when there is no will.
And really, what is that person's job?
That person's job is kind of to act as the middleman between the clerk of court to get things kind of switched over. And they will really just communicate with the clerk of court, communicate with me if they retain us to do so. But yeah, they're the middleman between the clerk of court and the beneficiaries to get things moved over.
They're getting those assets collected and transferred. Right?
Yes, that's right.
Which makes you think, if their job is to collect assets and transfer assets, real property is an asset. The administrator, executor takes that real property and they need to transfer it. So what's the problem here?
Yeah, so the problem is, and it's not a problem necessarily, but how North Carolina functions in their law is that if real property is kind of named in a will, or it passes as part of the estate that goes through the will, and it's named to specific beneficiaries in there, or just a class of beneficiaries in there, then it kind of transfers automatically, and it doesn't really go through the probate process like a cash would or other sort of assets like a vehicle would. So it really, by operation of law, when that person dies and mom dies and she leaves me her house and her will, then right when mom passes away, I'm the by law owner of that. I don't get a deed for it, but that property is my property at that point. So really the kind of the conflict there is between, and it's not necessarily conflict, but the issue is that the executor, as the personal representative of the estate, thinks, oh, it's my job to get all this stuff switched over. But for real property, it's kind of already done. It can sometimes have to be added back in if there's claims against the estate. That's getting into the weeds a little bit. But yeah, if there's real property listed in a will and it goes to specific beneficiaries, then it's those beneficiaries. And if they're going to sell that property, it's the beneficiaries who sign rather than the executor.
Yep. And that's what we see often, and this is something that I think is really critical for folks to understand, is this is the function of the law in North Carolina. So whenever I tell people as the real estate attorney that I know that you're the executor, but the real property passes outside of the estate. So it's going to go directly to the heirs or the beneficiaries under the will. If there's a will, it's going to go to whoever's named in the will. If there is no will, it's going to go to whoever the heirs of the person are, and they have to sign.
Yeah.
And then the other thing that gets folks really bent out of frame is their spouses have to sign. In North Carolina, that's just the way real property works, is if you're selling property and you don't have a prenuptial agreement or some kind of free trader agreement with your spouse will have to sign. Even though that property was their mom or dad's or whatever, it's just the way it is with real property.
Yeah.
So folks get really upset about that a lot of times, and it's something that I get it. It's like this wasn't my wife's family. What does this have to do with anything? It's just the way it is in North Carolina.
That's what we got to deal with.
Now, in some cases, though, where there's been some good estate planning, if the mom or dad or whoever has passed away wanted the property sold, they can direct that the executor sell the property, can't they? Yeah,
that's right. And that's some kind of the estate planning function of it. But yeah, and that's what we'll tell you if you come in and see us, is that we can kind of make it to where your executor has the choice to sell it if they want to, and it kind of involves giving it to the executor for the benefit of other people. It's not necessarily a trust, but it's kind of a, if you want the property to be sold, the executor can sell it. They can have the power to sign just in their name as the executor and kind of distribute those proceeds to your children or your beneficiaries or whoever that might be.
Exactly. So we've talked about the estate administration process, and we've talked about or at least which type of estate and that kind of thing. So probate assets versus non-probate assets. We've kind of started getting into that a little bit. So and real estate is not a probate asset. And what does that mean? It just means that it doesn't go through the estate, right?
Yeah, in a way, you can really kind of think about it as, and on the estate forms, there's kind of two sections, really. The first section is property of the estate, and those are what we'd call probate assets. And that's kind of things that the person owned alone. So your checking account that is just in their name, classic example of just a probate asset. Their vehicle that their name's the only name on the title, probate asset. What would be considered a non-probate asset or kind of a part 2 asset would be assets that can be added to the estate if needed to pay claims. But those are assets that are typically, account that is jointly owned with someone. So Luke and I own an account with rights to survivorship. If I pass away, that account is completely his. That's an example of kind of a non-probate asset. Vehicles that have rights of survivorship on the title, and there's a little bit of a distinction between vehicles there. But yeah, let's say we own a vehicle together as with rights of survivorship or joint owners with rights of survivorship, then when I pass away, it's completely Luke's. With vehicles, it is kind of interesting is that just because 2 names are on the title doesn't mean you own it with rights of survivorship.
Well, that's the same way with real property too.
Yeah. And so the clerk will essentially interpret that as, I own 50%, he owned 50%. When I pass away, my 50% is going to pass through my estate to, whoever is my heirs or beneficiaries. So, jointly owned, you could largely consider that a non-probate asset. If you owned it alone, that's going to be really probably considered a probate asset.
And it's going to have to go through that estate administration process. So once that estate's opened up, we've got to deal with these things called creditors. What are creditors?
Yeah, creditors are just what you'd think. They're people who, the decedent owed money to or owned some sort of legal obligation to or something along those lines. Typically, creditors are, credit card companies. Medicaid is a large creditor against estates. Hospitals, anything like that those are typically our creditors that we have to deal with after someone passes away.
And those things have different creditors have different priorities, right? I mean, as far as some get paid right off the bat, and some may not get paid. Yeah,
and there's a large list of kind of priority that's listed in the statute that it really depends on. Sometimes on chronological order, sometimes on what the claim was kind of tied to. So it's that's classic answer. It depends. They have different priority. So it's not all claims against the estate are equal.
And that's where you have to publish a notice to creditors, right? What is that?
So the notice to creditors is kind of a function of the full estate administration, and that is an ad that you run in the newspaper for 4 consecutive weeks that essentially serves as a notice to any creditors against this person's estate that they need to submit a written claim to the executor or the clerk of court that says this is how much I'm owed, this is what it's for, and then the clerk will kind of put that in the file, and then it'll be for the executor to kind of determine if it's a legitimate claim, and if it is, pay the claim out of the assets of that estate.
And that's one of the things that we can help with is determine, okay, is this an actual claim that you should be paying, or is this something that we should contest or deny?
Yeah, absolutely. These claims, they're typically legitimate, just because they know that they can be challenged. But we'll go through and look at it for you, kind of evaluate if it's a legitimate claim or not. And then a lot of times these creditors are willing to play ball as far as, if we say, hey, can we just give you kind of a payoff amount, and then you just write us a letter saying the claim is satisfied.
Yeah. So we can negotiate a little bit with the creditors. That's good. So as we're if we have to do this full estate administration process and we have to run the claims of creditors, that has to run for how long?
So it runs for 4 consecutive weeks, and it gives creditors 90 days from the first publication date to.
And that's it's in the newspaper, right?
That's right. Yeah.
Okay. And then after that published notice to creditors runs and you get all the creditors' claims and all that, what's the process after that?
Yeah, so after that runs, it really is just a matter of kind of paying the claims that we got during the claims period, and then after that, kind of showing our work to the clerk to see what claims were paid out of the assets of the estate.
It's like 5th grade math class, right?
It really is. The last form is the final account. It kind of shows what money has come in, what money has gone out and then what money's left over to distribute to the heirs of the beneficiaries.
Yeah,
So,
yeah.
and it sounds pretty straightforward, but you'd really be surprised sometimes how many kind of transactions can kind of happen here to show, sometimes it's the thing that is most frequent to me that typically causes the most work is kind of going through some of these accounts that people owned. And you think this account's just sitting there. Mom's account, nothing's getting charged out of mom's account anymore. But for months and months and months, there's been 2 cents in interest that's been coming into the account, and that has to be reflected on the final account. So
and service charges that are going out. And so
that's
you've got
right.
$1.25 here and $1.50 in, $1.50 out.
It's one of those things where even if there's a difference of 2 or 3 cents or a cent even on your inventory versus what you're showing to the clerks, they're going to say, what's this about? Where's the cent come from, or where'd the cent go? So
we have a form that we often have people sign when they do a real estate closing with us that says if we are ever audited and we find out that we're off by $5 or less, where we owe the client $5 or less, that we don't have to write a check for that amount, because we have to, and I don't know that folks understand, we have to account for things to the penny. Nobody else other than maybe banks has to deal with this with a penny.
Yeah.
Most people think, I'm off 5 cents. Who cares?
Yeah.
In the legal world, if I'm off 5 cents and I don't correct that and then I'm audited, I get in trouble over 5 stinking cents. It's crazy. But it's the same way in the estate administration world, isn't it?
Yeah, that's it. Same way. And they're going to check behind you for sure. It's their job to make sure that, they're signing off on it too, to say, yep, it's done correctly. Yeah. So they're not gonna put their job on the line because a penny's off. They're gonna make sure you're on the right track.
You gotta go find that penny.
That's right.
Yeah,
that's right.
Sometimes you just want to take it out of your pocket. There
you go. Yeah,
leave me alone.
Yeah,
Here's your penny.
I wish that worked.
Oh my goodness. Well, so we. I want to recap just a little bit. So one of the most important things, if it's not too late, come in and talk to us about doing some estate planning so we can avoid some of these headaches.
Absolutely.
If it is too late, that's fine. We can still help, and there's still things that we can do, maybe even help streamline the process where it doesn't take this year or 2 years to get it done. So come talk to us about what type of estate. Come talk to us first and let us help with that. And don't be in a rush to do that. It's okay to take your time and grieve, but come talk to us. And then we decide what type of estate to do and how to move that forward. If there's real property involved, how we deal with the real property and those kind of things. And then, once we get through that estate, it'll be fine. We'll figure it out. Yeah. It may take some time, but we'll get it done. And we're here to help with that. So what else on estates have we missed anything?
No, I think we've pretty well covered just about everything. And if it seems kind of like we didn't go through the process, it's just because the process is kind of just dependent on what's going on. But yeah, the general idea of someone passing away and the process of seeing what the most efficient way to get their stuff switched over from their name personally to their heirs, their beneficiaries' name, is kind of really the linchpin of what we're talking about here. And I think, we covered that, and it kind of all just circles back to, it depends. And that's why we're here. We're here to help you kind of get a plan in place to get this done as efficiently as possible.
And that's, we talk about these things in overarching themes, especially on our podcast here, because there's so many different ways that these issues can present themselves. And there's no one size fits all answer. Mm-hmm. Sometimes it's a combination of different things that we need to do. And that's why we're here. And that's what we want to do, is help you through those things and to navigate those things. So don't forget to like and subscribe to this podcast and watch our videos on YouTube and Facebook and get this information. Feel free to watch this before you come talk to us. Mm-hmm. And that way, you're kind of familiar with some of these terms that we use. And look, this is complicated. If you don't do it every day, to try to come in and do this on your own, it would just be a headache. That's and right. We do it every day, and so we're used to it. It's just like, if you work on heating and air or plumbing stuff all the time, to talk about that, who knows? Yeah. Or if you're a golf course designer, some of the things that you would do, you never know. So
second nature.
Watch these videos and call and make an appointment with Colin. And if you've not got an estate plan in place, man, we can help so much. There's so much value in avoiding some of the things that we've talked about today. Come and see this guy and he can help. So thank you so much for watching. You guys have a good day.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.